Hello everyone. A very good evening and welcome back to the Fortnightly Weekly Legal Scope. So today we'll be discussing the part 2 of our month of the May, and let's start. So to start with, we have this new information with respect to the appointment of new chairperson of the Competition Commission of India. So this Monday, the Ravneet Kaur, who is from 1988 Punjab cadre, and she's the IAS officer, she's been appointed as the new chairperson of the Competition Commission of India. Now, you might be wondering that what is Competition Commission of India? So basically, it is a statutory body which has been established by the government to protect the competition in the market. So this is the regulatory body and this enforces the market area. This regulates the market area to ensure the healthy competition. So Ravneet belongs from the IAS cadre. She's from 1988 Punjab cadre, and she is currently deputed as a additional chief secretary and financial commissioner at the Department of Revenue, Rehabilitation and Disaster Management in Chandigarh. So she was working there in the Chandigarh, and now she has been appointed as the new chairperson of the Competition Commission. Now, as per the order released by the government, so her appointment will be for the 5 years and from the date she assumes the charges or till the date of attaining the age of 65 years. So whichever is earlier, whichever gets completed earlier, she will be subjected to that. So either her 5 years will be over first or either she will attain the age of 65 first. So whatever happens earlier, the retirement will take place. Now, this specifically position of the chairperson of CCI, this has been kept vacant since the previous office holder Ashok Kumar Gupta. So Ashok Kumar Gupta retired in the October last year, and since then it's been going to be almost going to be 8 months. So from last 8 months, this office has been kept vacant. Now, as soon as the Ashok Kumar Gupta retired in the October, Sangeeta Verma has been appointed as the acting chairperson. And now finally we have a permanent chairperson, Ravneet Kaur. Justice N. Ramachandra Rao has been appointed as Chief Justice of Himachal Pradesh High Court. So this last Friday, the central government have notified the appointment of Justice M.S. Ramachandra Rao. So he has been appointed as the Chief Justice of the Himachal Pradesh High Court. Now, one interesting fact I would like to tell you guys regarding the appointment of Chief Justice in the High Court is that you will always find that the person who has been appointed as the Chief Justice of a particular High Court never belongs from that state. Now, this specific condition has been put up in order to enhance the system of unbiasedness. So, for example, if I belong from the state of Maharashtra and if I've been appointed as a Chief Justice of the state of Maharashtra, then there are high chances that I may be biased because I know a lot of people, I know a lot of organization and firms. So there is a chance that I may be biased toward those particular organization. Something which is known and something which is unknown. Both scenarios it could be possible. That is why to ensure the principle of unbiasedness, it has been established that the particular Chief Justice of the High Court will never belong from the parent state, right? That is why you will see that all the Chief Justices and all the High Courts of our country are not from that particular state. So, Office of Chief Justice of Himachal Pradesh High Court has been kept vacant since January this year after the retirement of Chief Justice Amjad Saeed. So this office had been kept vacant, and the Supreme Court Collegium, which was headed by D.Y. Chandrachud, our CJI, so they have recommended the Justice Rao's elevation last month. Now, what is collegium? Collegium is a very prominent term which you will hear again and again, and I have told previously also that collegium is the body of senior most judges, including the Chief Justice of India, Apart from Chief Justice of India, there are four senior most judges, and they decide that whom judge will be appointed at what court and under what position. So, including the elevation to the Supreme Court, or any judge has to be appointed as the Chief Justice of any High Court. So, all of this, the appointment matters has been dealt by the collegium. Justice M. Ramchandra Rao was appointed as the judge of the High Court of Andhra Pradesh on 29th June 2012. So, Justice Ramchandra Rao entered into the field of judiciary back in 2012. And then, when the state of Andhra Pradesh got bifurcated, so the judges had been given an option that which state they want to be, right? Which state they want to get placed. So Justice Rao at that point of time opted for Telangana and not for the Andhra Pradesh. So he belonged from Telangana High Court, and thereafter in 2021 he has been shifted to the High Court of Punjab and Haryana, and from now he has become the Chief Justice of Himachal Pradesh High Court. So see a lot of variation. From Telangana he's been to Punjab, and from Punjab he's becoming the Chief Justice of Himachal Pradesh High Court. So this is just to ensure the principle of unbiasedness. On a parallel line, Justice Augustine George Massey has been appointed as Chief Justice of the Rajasthan High Court. So, as we got to know that how a Chief Justice has been appointed and by the collegium headed by the Chief Justice of India. So again, the Chief Justice of India, D.Y. Chandrachud, recommended the Justice Massey as to be the CJ of Rajasthan High Court. So Justice Massey has taken birth in 1963 March 12 at Ropar, Punjab, and then he has completed his studies from the Kasauli, Himachal Pradesh, and then from Aligarh, Uttar Pradesh. And then he started his career as an advocate. So he used to appear before the courts in Punjab, Haryana, and Delhi. And later on, he took up the judiciary. Now, the next is that this is something very important, that government servants have a right to form association. Now, this is one of the very prominent fundamental right which have been given in our Indian Constitution. So our Indian Constitution under Article 19(1)(c), as you can see in the slide here, Article 19(1)(c) of the Indian Constitution gives us a freedom that we can form association, we can form unions. That is why you will see there are a lot of political unions, like we can see ABVP, NSUI, then there are different clubs, like there is a very prominent club called Gym Khana Club, right? Like this, there are multiple association, badminton association, tennis association. So like this, you have a freedom, you have this fundamental right that you can create any association, any union. So basically, this is a group of people who belong from the like-minded thought. So they want to pursue the same thing. So now the issue in this particular matter was whether the government servant should be allowed to form associations or unions or not. So this was the issue, in which Delhi High Court has given a clarification that government servants should not be excluded from this fundamental right. Now, one aspect in this is that fundamental right has been given, or fundamental right is provided to all the citizens of our country, and government servants are also a part of our country. They are also citizens. So they are citizen first and the government servant secondly, right? That is the secondary identity of an individual about their profession. So they are citizen first. So the Delhi High Court said that this is a very prominent right which has been granted to us. Now, fundamental right have been enshrined in the part 3 of the Constitution of India. And in part 3, specifically, Article 19 talks about the freedoms. So there are 6 types of freedom which have been given to an individual by the Constitution, and this is considered as a fundamental right. Now, under Article 19, as I mentioned you, that there are 6 freedoms. So starting from A, B, C, D, E, F. So you can see that it is a third one, Article 19(1)(c), right? This is the bifurcation, 19(1)(c). So this is the third one which talks about right to form association or cooperative society. So this is a fundamental right, and fundamental right is enforceable in the court of law. So whenever any violation of fundamental right takes place, we have the opportunity that we can represent our matter in the Supreme Court or High Court. Supreme Court Judges Library. So we have recently got Asia's largest law library. So it is the Supreme Court Judges Library. This is going to be the Asia's largest law library. So when we talk about the Supreme Court's Judges Library, so it started functioning in 1937. So we had one Princess Chamber in the old Parliament House, and that had a sort of library. Now the new construction has took place, and it is a four-story building, which is state-of-the-art building, spanning around 12,000 square feet in Block A of the new additional building complex of Supreme Court. So Supreme Court has spread in a very wide area in New Delhi, and in that, in 12,000 square feet area, they have made this Asia's largest law library. The main building of the Supreme Court, which still houses the two floors of library, is functioning to accommodate the immediate needs. So our library's major role is that a whole structure of court belongs upon the research. So if it is built upon the research, if it is built upon the different sorts of judgments and the theories and the philosophies which the judges rely while giving judgment, so it is very important that we must have a very wide library. So for a judge, it is very important that while giving any judgment in any matter, the judge must have a prior research on the specific matter. So when we talk about research, the word research means specifically when we talk about legal research. So the legal research comprises of the studying of different theories, different concepts, different case laws, different statutes, different judgments given by the other courts, or different judgments given by the foreign courts, so that we can take an idea that what could be the right punishment, or what could be the right justice under the specific case. So this is not a new concept. Even when our constitution was getting formed in 1947, our constitution started getting framed in 1947 and got finished in 26th November 1949. So during this duration, it is an established fact that our constitution has been made by borrowing the different features of different countries. So we have borrowed the features from Japan, we have borrowed the features from US, from Germany, right? From United Kingdom, from multiple places we have brought the features, because whenever we make something, we do a research. So we have to do a research because this gives us an idea that what is the best suitability according to our own circumstances and conditions. So that is why having a very prominent library is a must. And that is why you will find that it is a identity of any law school. So this is one of the parameters which you can, if you are a law aspirant, it is very important for you to remember that whenever you are going to select a law college, you should must inquire about the area, which should must inquire about the library, what they have. Because if a law college does not have a proper library, trust me, the base of law college is empty, because whole legal system is based upon the books or the journals or the case laws we have. These are our assets. So all of these are considered as an asset for a person who is in the legal arena. So you should must see that what capacity a library has wherever you are going to study, because that will give you a lot of insight. We had a very prominent history behind in order to understand that how our legal framework has conceptualized, starting from the Vedic era, what sort of legal system we had till the emergence of East India Company, and then how British started ruling with the different Charter Act, different regulations, and how the government of India has started getting control over the legal system, over the legislation over a period of time. And finally, in 1947, when we got independence, we got our own constitution. So this is such a beautiful history in terms of our legal background. So that is why a good library is a must. Now this library has total of 3,78,000 of material, and which includes books, journals, monograph, law journals, statutes, and a lot of things, different committee reports, different legislations. So all of this are required in order to have a sound understanding of any legal subject matter. Then the library subscribes to 131 journals. Out of them, 107 are Indian journals and 24 are foreign journals. Then they subscribe to 19 newspapers and 8 magazines. And the very surprising fact is, I will tell you that how our justices work. So you can see here that the very unique task which is performed by the library is that they start their work from 4 a.m. in the morning. And what do they do is they go through the e-papers. Now we have a concept of e-paper. The whole library team, the which has a team of 4 to 5 people who has been assigned this task of reporting Chief Justice of India. So they go through all the e-papers starting from 4 a.m. up till 6 a.m. in the morning. They prepare a detailed report, and the report is presented to the Chief Justice by 6:30 a.m. in the morning. That is why our judicial people, our judiciary is strong in terms of law, because there is a whole set of people who are working behind to make them aware, to make them assess with the contemporary legal knowledge. So this is the speciality, and this is the relevance and importance of having a library in our this own system. Now, we need to understand when we talk about this, why many people have seen that having a law library is not enough. The quality, the content, and the resources, the team who is working there is also parallelly important. So therefore, it is very much needed that we have a quality team who can work upon it. So it is very important that we must have a capable team who can handle this. So as we have seen in the previous slide, that what is freedom of speech, right? Freedom, we have seen that Article 19 gives us a different sort of freedom. So one of the important freedom is freedom of speech. So when we talk about freedom of speech, it is very important that we do have a sound knowledge, right? So many times people use freedom of speech for a wrong purpose or out of ignorance. So the libraries help us to have a very sound understanding, to have a very prominent legal background, so that we can assess, analyze, and then we can say that there are certain things, there are certain issues which are lagging behind in our country. For example, we see about data privacy. Data privacy in the present time is one of the most important matter which is bothering every citizen. The inculcation of the various social medias are leading to nothing but stealing the data out of our own smartphones. But unfortunately, we do not have any specific law which can control the particular issue. We have a right to privacy. So this is a very important aspect which we should think upon, it should bother us that we are lagging behind in some of the area. Now, the task of an individual is to raise a voice. That is why freedom of speech is given. So, unless and until you have a sound legal background, you can see that how other countries are working into it. So, thus, it is important that we should have a very good library, and so that we can encapsulate our fundamental right and the different rights and the protection given to us by the constitution. So with this, we will end our today's session. If anyone has any doubt, please write down in the comments and we'll go ahead with it. Okay, so since there are no doubts, so we'll end the session for today and see you guys next week.